Hello viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In the present module, we will learn about the rights of coparceners. Objectives of the present module are firstly, introduction, then meaning of coparceners, then coparcenary property, also impact on women brought about by 2005 Hindu Succession Amendment Act, then rights of coparceners, and finally the conclusion. Let's begin with the introduction and meaning. A Hindu undivided family, HUF, is a unique legal concept governed by Hindu law. It represents a family unit that includes all lineal descendants of a common ancestor and their wives. A coparcener is a smaller unit within a Hindu joint family that includes the eldest member and 3 generations of a family. Under the Hindu joint family, coparceners as an institution have a significant role in preserving and protecting the ancestral property. Earlier, the concept of coparceners was thought to be associated with the spiritual aspects, but now it is linked with the legal perspectives of identifying rights and obligations of the coparceners in the property. The head of the coparcenery is called the Karta. Here, it is important to understand the term coparceners. The word coparcener has its origin in the late Middle English era. And according to Lexico, coparceners means a person who has equal shares with others in the inheritance of an undivided estate. The Collins Dictionary defines the term as a person who is a co-heir and inherits an estate with others. In the context of Hindu laws, a coparcener is a person who has a legal right to his ancestral property by birth. As per the Hindu Succession Act of 1956, a coparcener is a person who can claim a right over ancestral property by birth. A coparcener is a member of the Hindu undivided family HUF who can demand the partition of the property. The eldest member of an HUF and the following 3 generations constitute a coparcenery under Hindu law. This means the list of coparceners in a coparcenery is made of the head of the family or Karta along with his sons, grandsons and great-grandsons. Traditionally, coparcenery rights were restricted to male Hindu joint family members, while women were simply members. Since their status within the family was different, the legal protections were different. Daughters and mothers were only entitled to maintenance payments from the Hindu joint family assets, but a coparcener might legally seek a division of the property. Additionally, women were not permitted to become Karta of a Hindu joint family. Only men were. However, the Hindu Succession Amendment Act 2005 brought significant changes by granting equal property rights to daughters as coparceners. Therefore, male and female Hindu joint family members can now be coparceners. Sons or daughters both are considered to be coparceners and share equal legal rights and liabilities over their ancestral property. Now, according to Section 6 of the Hindu Succession Act 1956, the Hindu joint family, which is governed by Mitakshara law, the daughter of such a family as a coparcener, by birth she can become a coparcener in her own right. Secondly, subjected to the same rights in the coparcenery property like that of a son, and subjected to the same liabilities with respect to the coparcenery property as that of a son. Let's discuss the status of married daughter. Until the rule was changed in 2005, when a daughter got married, she automatically ceased to be a member of the Hindu joint family, and as a result, lost any claim she might have had to maintenance payments or share of the Hindu joint family's assets in the event of partition of those assets after the marriage. As now, the daughter is made the coparcener in the same manner as that of a son. It means that her subsequent marriage will not affect her status as a coparcener, and she will continue to remain a coparcener in her father's joint family property. Though the daughter ceases to be a part of her parental Hindu joint family, she continues to remain a coparcener. That means she is also entitled to request the partition of her joint Hindu family property and also become the karta in case she is the eldest. In case of the married daughter's death, her children will receive her share. Who can be a coparcener? Following the Mitaksha system, this interest over coparcenary property is acquired by birth. Whenever there is a birth of a son or a daughter in the family, he or she becomes a coparcener in the Hindu joint family and acquires undivided interest over the coparcenary property naturally. A child brought in the family through adoption also becomes a coparcener. This means the share of coparceners in a property is not static. It can be diminished or enlarged by the birth or death of any other members of the coparcenary, respectively. However, one's interest in the property remains undivided. Now let's discuss difference between joint Hindu family and coparcenary. A joint family is a bigger institution, and within the joint family, there is a smaller institution called coparcenary. In a joint family, there is an expansion of the family with the birth, death, or marriage of a person. But in the coparcenary, members can only be added by birth or adoption. In the joint family system, all the members do not possess equal rights over the joint family property, whereas in coparcenary, all the members have equal interest in the coparcenary property. The coparceners who are disqualified continue to retain the status of a joint family member but are not considered as part of the coparcenary and therefore cannot ask for a partition. A Hindu joint family is perpetual in the sense that it remains unaffected by the birth or death of its family members. Every coparcener will definitely be called a member of the joint family, but every member of the joint family cannot be termed as a coparcener. As far as difference between coparceners and non-coparcener members of a Hindu joint family is concerned, a coparcener has the right to claim partition while a member cannot. This is the key distinguishing factor between a coparcener and a member. For instance, a wife is considered a member but not a coparcener. Therefore, a wife does not have the right to claim partition. However, in case of a partition between her husband and children, she will receive an equal share, which will be her absolute property. On the other hand, a widow can fill the shoes of her deceased husband and raise a claim on partition. A daughter also has equal rights to claim partition. In this scenario, she will possess similar rights to a son. What is coparcenary property? Coparcenary property refers to this joint family's ancestral property, which excludes self-acquired holdings. It is referred to as ancestral property if it is passed down through 4 generations of the male bloodline. Even though Hindu law grants the head of a Hindu undivided family or karta the ability to administer this ancestral property, the coparceners share the rights to this ancestral property or coparcener property. Under Mitaksha law, coparcener is a creation of law, where the coparcener acquires the interest in the property by birth, provided that the coparcener falls within the category of 3 generations from the last holder of the property. Also, the share of the coparceners is not specific and is subject to fluctuations with the birth and death of the other coparceners in the family. Under Dayabhag law, the coparceners have no right to acquire property by birth, and the doctrine of fluctuating interest is not applicable here. Now let's discuss impact on women brought about by the 2005 Hindu Succession Amendment Act. Following the enactment of new language in Section 6 of the Hindu Succession Act on September 9, 2005, females now have the same legal standing as sons when it comes to inheriting property and can use the coparcener designation. A girl born into a Hindu joint family governed by Mitakshara law will, as of the date of the Act's implementation, enjoy the same rights to her father's coparcenary property as he does to his sons. Partitions and bequests effected before December 20, 2004 are not affected by this provision. As a result, daughters can now act as the karta of a Hindu joint family and ask for a fair share of the family's property. But only daughters can make the transition from member to coparcener. Daughter-in-laws are not covered in the concept of coparcenary. It is important to note that after a daughter marries, she will no longer be regarded as a member of the parents' Hindu joint family. But the Hindu joint family will still count her as a coparcener. If she passes away, her children would be eligible for a portion of the Hindu joint family's property when it is divided. In the event that she has no surviving children, her grandkids may be entitled to inherit her estate. The Supreme Court has affirmed the coparcenary rights of daughters. Uncertainty about whether Section 6 is prospective or retrospective and whether it applies to women born after 2005 has led to differing interpretations of said 2005 amendment by several high as well as the Supreme Court over the past years. According to the Supreme Court ruling in Vinita Sharma versus Rakesh Sharma and others, 2020, daughters shall retain coparcenary rights on their father's property even though he died well before the Hindu Succession Amendment Act 2005 entered into effect. According to the revised Section 6 of the Hindu Succession Act, daughters born before or after change are given coparcener status. That is, they are equal shareholders while inheriting properties, giving them the same rights and responsibilities as sons when it comes to property inheritance. The Supreme Court concluded that the 2005 amendment was retrospective because the right to coparcenary is founded on birth, meaning that the father of a coparcener need not be alive on September 9, 2005, the day the statute took effect. However, it is to be noted that any recorded settlements or partition litigation decreed before December 20, 2004 will not be revisited. Right to property as coparcener differs from right to maintenance. The Dharwar bench of Karnataka High Court has clarified that granting property to a wife or daughter for maintenance differs from allotting them a share in the property. Justice Anant Ramnath Hegde, presiding as a single judge, further emphasized that exceptions to Section 6 Clause 1 of the Hindu Succession Act 1956 do not hold if the partition of property contradicts a court order. Dear learners, now let's discuss the rights of the coparceners. Coparcenary rights primarily apply to Hindu families as governed by the Hindu Succession Act. It mentions that other religions may have their laws and provisions regarding ancestral property and inheritance. The rights of coparceners in a Hindu joint family are, firstly, right by birth in the property. A Coparcener has a right by birth in the coparcenary property, and his interest over the property is similar to that possessed by his father. For example, suppose A is the head of the joint Hindu family and possesses one bungalow in Delhi, and he has three sons named B, C, and D. Then, by virtue of being born in the family, B, C, and D have a valid right over the ancestral property, that is, the bungalow. In the case of Mandali Prasad versus Ram Charan Lal, 1947, it was held that the moment a Coparcener is born to the family, he enjoys the same rights over the coparcenary property like that of his father. Next one is communal interest and possession. All the coparceners are the collective owners of the property. That is, they possess the title over the coparcenary property. A coparcener does not have exclusive custody of or any particular stake in the coparcenary property according to Hindu law. The members of the Hindu joint family have a shared unity when it comes to their legal rights over coparcenary property. It also indicates that they are jointly liable to pay the debts of the family, and without the consent of the coparceners, the property cannot be alienated. Next is right of common enjoyment of the coparcenary property. The right of common enjoyment means that until the time physical division of the property takes place, no coparcener can claim a specific portion of the property as his exact share is not known. Enjoyment also means the right of residence and right of maintenance. For example, suppose A builds a flat on a vacant joint family property, then he cannot claim his exclusive right over that property, as all the other coparceners have a common right to enjoy the property. In State Bank of India versus Ghamandi Ram 1969, it was decided that the coparceners have the right to common enjoyment of the coparcenary property, which means that no coparcener can claim a specific share in the property until the time actual division of the property occurs. Next is share of the coparceners. Under the Mitakshara law, the share of a coparcener fluctuates with the birth and death of other coparceners, and this continues until the actual partition takes place in the family. This share increases when a person dies in HUF and decreases with the addition to the family. The share becomes defined whenever there is a partition of the property. Next is right to joint possession. Every member of the HUF has the right to enjoy the coparcenary property and has the right to possession over the property. Next one is right to maintenance. A coparcener is entitled to get the maintenance of the coparcenary property from the state of the family. The coparcener receives money from the property for the maintenance of his wife and children, or in case of a marriage ceremony of the same children. Restraining improper use. According to Hindu law, if a coparcener misuses the coparcenary property, the other coparceners can restrain him from any further use or have legal rights over the property. Next is right to demand partition. Every coparcener, whether young or adult, has the right to demand partition of the family property. In this case too, he cannot demand a definite share as it is fixed after the partition. Under the Mitakshara school, the coparcener has the right to ask for partition by birth. But under the Dayabhag law, the coparcener cannot ask for partition till the time when the father is alive. Next is right to accounts. A coparcener has the right to ask for accounts in case of fraud or misappropriation of income. It is to be noted that the position of the Karta, who is the senior most member of the family, is considered sacred, and he is deemed to work in the best interest of the family. So, he is generally not bound to maintain the accounts of the family. But there are certain exceptional situations in which he is bound to do so, like conducting a family business in which maintaining accounts is a necessity, or charges of fraud or misappropriation of income are there, or when any copartner asks for a partition. Next is right to alienation. As a general rule, copartners are not allowed to sell their portion in the ancestral property without the consent of other copartners because of the principle of community of interest and unity in possession. Next one is right to manage. Although Karta has power over the ancestral property, it does not mean that he is able to affect the interest or share of the property between the copartners. Next is right to challenge an unauthorized alienation. In the joint family, the power of alienation rests with the Karta, and he can exercise this power without the consent of other copartners only in three situations: legal necessity, benefit of estate, and performance of some religious duties. In the scenario where the Karta sells the joint family property for an unauthorized purpose, the remaining copartners have the following remedies. If the copartner is aware that Karta is going to alienate his share, he can ask for a partition. Secondly, injunction order from a court obtained by other copartners. Then, in the case where the alienation is already being done, it can be challenged by other copartners as invalid, and it is not binding on them. But the burden of proof in such cases lies on the alienee, that is, the person to whom the property is being transferred, to prove that the Karta was really authorized to sell the property. Next is right to make acquisitions. A copartner, along with exercising his right over ancestral property, can also possess his own separate property at the same time. He can earn money through his special skills or by performing a job in a corporate firm. If the copartner so desires, he can also blend his separate property into the joint family property. But he cannot convert any portion of the joint family property into his own separate share. Next is right to renounce his interest. Renunciation does not signify partition, but it can be understood simply as a reduction of shares. A copartner is given a right that he can renounce his undivided share in the joint family property in favor of other remaining copartners. But the same two conditions need to be fulfilled. Renunciation shall be valid of the whole share. Secondly, renunciation should be in favor of other copartners. A copartner who had once renounced his share in the property is not entitled to get his share back even during the time of partition. Dear learners, on the basis of our discussion, we may conclude that the concept of copartnery has evolved significantly, which is easily visible from the changes introduced in the Hindu Succession Amendment Act 2005. To make the changes brought in by the concept of copartnery successful, what is required is that these changes should not exist merely on paper but should work practically as well. The people need to broaden their mindsets and should try to accept that daughters also have a valid right to become copartners, and daughters should also stand up for their rights in the property. With this, we come to the end of today's lecture. Thank you very much.